Today we are looking at the different types of vitiating factors that can prevent a meeting of the minds. As we have already seen, for a contract to come into existence, it is necessary to have a meeting of the minds between the parties. A meeting of the minds is said to occur when the parties to a contract both have the same understanding of the terms of the offer and acceptance that has occurred between them. Such a mutual comprehension is essential to the formation of a valid contract in the common law. This meeting of the minds will not be considered to exist where one of the parties can demonstrate the presence of one of the following vitiating factors: mistake, misrepresentation, duress, undue influence, or unconscionability at the time of the formation of the contract. Now let's look at the area of mistake. The presence of a misunderstanding or mistake at the time of entering into the contract may lead the courts to find that there has been no meeting of the minds between the parties. However, for a mistake to prevent a contract from coming into existence, it must concern a material or fundamental element of the contract, i.e., the mistake must go right to the heart of the contract. If the mistake concerns a trivial question of minor importance or an error of judgment, it will not invalidate the contract. For example, if X sells his replica Ferrari to Y, and Y, mistakenly thinking it to be a genuine Ferrari, pays X more money than the car is worth, such a mistake will not invalidate the contract on grounds of mistake. Should Y be able to demonstrate that X deceived him into thinking the car was a real Ferrari, then Y can seek to invalidate the contract on the grounds of fraudulent misrepresentation rather than mistake. There are three different categories of mistake recognized by the law. 1. Unilateral mistake. Unilateral mistake is said to occur when only one of the parties to the contract makes an error. In the absence of fraud, the courts are normally willing to enforce a contract in spite of a mistake made by one of the parties. Thus, they are not normally willing to consider a contract unenforceable on grounds of unilateral mistake. 2. Common mistake. Common mistake occurs when both parties are mistaken about the same issue. For example, in the case of Couturier and Hasty, the parties agreed to the sale of a cargo of corn which, at the time of the agreement, they both mistakenly thought was being transported by ship. However, unknown to both of them, the captain of the ship had already sold the corn to someone else. As neither of them could have reasonably been expected to know the corn was already sold, the contract between them was considered void on grounds of their common mistake. 3. Mutual mistake. Mutual mistake occurs when the parties are at cross purposes. For examples, in Raffles and Wichelhaus, the parties agreed to the sale of a load of cotton on board a ship called the Peerless, leaving Bombay in October. However, unbeknownst to the parties, there were two ships called Peerless leaving Bombay that October, one at the beginning of the month and the other at the end of the month. As one party thought that their agreement concerned the Peerless ship leaving early in the month, and the other that it concerned the Peerless leaving at the end of the month, the court declared the contract was void and unenforceable as a result of the parties' mutual mistake. Now let's look at the area of misrepresentation. Misrepresentation occurs when one party makes an incorrect statement to the other party that induces the latter to enter into the contract. The statement, although significant, is not considered important enough to be an actual term of the contract. If it were a term of the contract, the deceived party would have an action in breach of contract. For example, if X claims to Y that the car he is selling has only had one previous owner when it had two, X may be said to have misrepresented this fact to Y. There are three types of misrepresentation. There are three different types of misrepresentation. The first is fraudulent misrepresentation. Fraudulent misrepresentation occurs where one party X knowingly misrepresents an important or material fact that induces another party Y to enter into the contract. For example, X informs Y that the car that he is selling is 2 years old when in fact it was constructed 10 years ago. If X knows that the car is 10 years old, he will be guilty of fraudulent misrepresentation, and Y may repudiate or reject the contract and seek damages for any loss that he has suffered. For a finding of fraudulent misrepresentation against X, Y must demonstrate to the court that 1. X misrepresented a material fact to the plaintiff. 2. The misrepresentation was made knowingly or recklessly with the intent to defraud. And 3. That Y relied on the misrepresentation when entering into the contract and suffered financial loss as a result. Once fraudulent misrepresentation is established, the victim may immediately repudiate the contract without the need to inform the other party. Alternatively, he may apply to the courts for an order of rescission and also request damages. However, instead of applying to have the contract rescinded, the injured party may choose to affirm the contract but request monetary compensation for any loss he suffered as a result of the misrepresentation. The second type of misrepresentation is innocent misrepresentation. Innocent misrepresentation differs from fraudulent misrepresentation as the party making the misrepresentation does not know that the representation is false. Thus, the statement is not made with the intention to defraud the other party. In the US, innocent misrepresentation does not give a right to damages, and the only remedy normally available to the victim is rescission of the contract. However, in the United Kingdom, under the 1967 Misrepresentation Act, the courts may decide to award limited damages for any direct damages suffered by the plaintiff resulting from the misrepresentation. The third type of misrepresentation is negligent misrepresentation. In the 1960s, the courts recognized the existence of negligent misrepresentation. Negligent misrepresentation occurs where one party unknowingly makes a non-true statement to the other, which, had that party taken reasonable care, they would have known to be untrue, i.e., they were negligent. Developed under the heading of tort law, the area of negligent misrepresentation is now governed in the UK by the 1967 Misrepresentation Act. Now let's look at the area of duress. Not surprisingly, if Y agrees to enter into a contract with X because the latter is holding a gun to his head, the courts will probably be of the opinion that there has not been a true meeting of the minds. This is an example of duress, which is defined as coercion, either physical, mental, or economic, administered by one party, depriving the other party of their free will as regards the decision to enter into a contract. In the United Kingdom, contracts entered into under duress are voidable and not void. Thus, the party claiming duress must inform the other party that they are repudiating the contract. Now let's look at undue influence. When one party takes advantage of another by reason of their being in a superior influential position, it is considered to be a case of undue influence. When this occurs, the contract is said to be voidable and a weaker party has the right to repudiate the contract entered into with the stronger party. Cases coming under the heading of undue influence can be broken up into two categories. The first concerns cases where the parties are in a fiduciary relationship. Where the parties are in a fiduciary relationship, there is a presumption of undue influence, and the courts will not hesitate to set the contract aside where it is clearly disadvantageous for the weaker party. Fiduciary relationships are said to arise, inter alia, in the cases of agreements between parents and child, lawyer-client, religious advisor and believer, investment advisor-client, and trustee-beneficiary. A husband and wife are not considered to be in a fiduciary relationship. The second case concerns cases where the parties are not in a special fiduciary relationship. In cases where the parties are not in a special fiduciary relationship, the burden of proof falls on the alleged victim of the undue influence. Now let's look at the area of unconscionability. In certain limited circumstances, the courts are willing to accept that a person is not bound by their contractual obligations when, at the time the contract was entered into, there was excessive inequality concerning their respective bargaining positions. In order to succeed in an action based on unconscionability, it is necessary to show that one of the parties was in a greatly superior bargaining position to the other, and that this position was exploited by the imposition of unconscionable terms. The terms imposed must be shocking in their extremity and clearly offensive. Unconscionability has been applied most frequently in the case of consumer contracts, where businesses have imposed unfair terms on consumers, especially in the case of adhesion contracts, also referred to as standard form contracts. We hope you enjoyed this introduction to the different vitiating factors that may prevent the formation of a contract in the common law world.